You wrote in an article on the Practical Litigator, and there have been very rare cases calling for lightning speed, in which the court found it practicable to respond. I was reminded particularly of the Saboteurs case, ex parte Quirin. I remember this well because it arose in the summer of 1942 when I was senior law clerk to Chief Justice Stone, who was away at Peckett's in Sugar Hill, New Hampshire. The Chief Justice let me know that a special session of the court was about to be convened to deal with the captured German saboteurs' claim that their trial before the Military Commission, which President Roosevelt had constituted on July 2nd, was unconstitutional and otherwise illegal. The court convened on July 29th in what was then called a special term. That's the scene you set in the article. Give us kind of a verbal overview of the buzz that was going on in Washington at this time concerning this really special proceeding.
Well, first, a lot of interesting things happened. One was that Stone's son, Lawson, who was an officer in the Army, had been designated one of the military officers to be counsel to the saboteurs. So the question came up whether Stone should sit in the case. And that was one question. I'll come back to it. The question came up of the court being sure that the saboteurs' counsel in the court was competent counsel. And Kenneth Royal was appointed, who later was Secretary of War. And I listened to that argument for the 2 days it was argued. Kenneth Royal couldn't have argued it better for his side. I thought he was, considering his small familiarity with it and how quickly it had come up, I thought he did an excellent job. And nobody could say that these people didn't have the benefit of competent counsel. Coming back to Stone's participation, his son Lawson had no connection with the effort to file petitions for habeas corpus in the courts. He wasn't connected with it, and he wouldn't. And counsel for both sides in open court, both the Attorney General and Colonel Royal, urged Stone to sit, and this is in the court's journal. And Stone therefore sat.
Now, Justice Murphy had recused himself.
He certainly had.
Okay. And the reason?
The reason? Well, he had gotten himself activated as a lieutenant colonel in the reserve, and his picture had appeared on the front page of the New York Times on his belly behind a machine gun. He had done all this without consulting anybody on the court, and it was obviously inappropriate for him to sit, and even Murphy knew that.
Is it true that he showed up in uniform on the day of the argument, intending to sit, and had to be persuaded?
I don't think so.
Okay.
I don't know that it wasn't, but I don't think so.
Tell me a little bit about what you listened to the arguments.
Yeah.
Then clearly that was the case of the special term.
The court considered it and issued a per curiam relatively quickly, and 6 of the 8 people were executed.
Did Stone have, after the conference, there was a conference, and did Stone talk to you at all about this?
Yeah, we circulated a per curiam. There was a sentence in it Bill Douglas didn't like, as I recall, and we took it out. And the per curiam was issued unanimously.
Was the expectation that the execution was imminent no matter what the court did?
Well, it was imminent unless the court stopped it.
Well, I guess I'm asking whether...
You're asking whether the president would have
whether the president
defied
was expected to obey.
Who knows? I mean, I realize that you can dig up something in which the president allegedly said to Biddle or whatever, that he didn't care what the court. I'm not questioning that he might have said that.
Right.
I don't believe he would have done it, but who knows?
On the court side, well, in Stone's chambers, was that topic discussed, the prospect of executive disobedience?
I would have to say that at a distance of 60 some odd years, I haven't the slightest recollection.
Okay.
Then the per curiam is rendered, and then the hard part of a decision, or not a decision, but
An opinion, as distinct from a decision.
Yeah, thank
The
you.
decision had been made.
That's right. Decision been made, clearly opinion, and now the rationalization for the decision.
Yep.
You were involved in all that. I mean,
Yes, I was. And the inside history of it has been published by Mr. Mason, who wrote the biography of Stone, and before the biography was finished, published a chapter on that episode in the Harvard Law Review. And in something else I've written for the Supreme Court Historical Society's Quarterly, I described my relations with Mr. Mason on that matter.
I think you're in the Practical Litigator, you're quoted as saying, I previously commented rather disapprovingly on the fact that Mr. Mason disclosed these internal documents.
Yeah, that's true. But that was a special case. 4 of the justices who had participated in that decision were still sitting on the court.
Mm-hmm.
So you have the question, when, even assuming that history has its claims, the question is, when does it have its claims?
Right.
I thought it was too soon.
Didn't the Stone family give Mason carte blanche to publish?
The Stone family put no restriction on Mason.
So it was a matter of his judgment.
It was a matter of his judgment.
Okay. Did he ever respond to you or other critics?
Yes.
And what was his?
I know what he said. He said he had gone around to several justices of the court to ask them whether they had any objection. That Black had said he had no objection. That Felix had said that there was a very heavy responsibility for a biographer to decide a matter like this. And he thought Felix was giving him a green light, and Felix thought he was giving him a red light.
Mm-hmm.
I later found out from Felix.
Okay.
He got some ambiguous answers that he thought were okays from, I think, Douglas and Reed.
Was that limited to Quirin, or was that more
No,
general?
no,
The
Quirin.
book.
No, Quirin.
Oh, cool. Okay.
And as you know, the Harvard Law Review published it without checking with anybody else, on the assumption that Mason had done all the clearances that were required.
Right. As long as we're on Mason, what's your view of his Stone book overall?
It's a terribly interesting book.
It is.
And one reason is that he had access to the letters that Stone wrote weekly to his 2 sons about what was going on in the court.
Mm-hmm.
Now, a little too much, I think Mason takes everything in those letters at absolute face value, on the assumption that the only view about what was going on would be whatever Stone said. And I think sometimes that probably isn't a fair thing to do. But that's what helps make the book very interesting, is access to the papers.